Turn the mic. That would be helpful. All right. Welcome back to Internet Law Review. Hope everyone's having a good day. We're going to do a few more stories and see what's going on. So just, yeah. Yeah. Cool. Hey, Andy. How's it going? Hey, Evan. How's it going? Or Ewan. Ewan Marshall. Ewan? Is that right? Ewan? All right. Somewhere between 120 and 3,150 stories. Of course. Nothing less than for you guys. Yeah, today we're just going to cover all the U.S. Supreme Court cases, all of them, since the beginning of time. So let's get started. That'd be good. Just finished watching Sticks and Stones. What is that? Like, is that like a Netflix thing? Is that a Netflix show? Sounds like a cool story. Um, anyways, let's get started. Water with a little crystal light in it. Fantastic. No calories, little flavoring. Very good stuff. All right. For our next story, we have the Supreme Court of the state of Georgia. This is a case dealing with child neglect, in which the parents of a child who essentially starved their child to death were convicted and their sentence was upheld. So we're going to read the facts of this particular case and see what happened, because it was a pretty interesting story I ran across and thought it was a good opportunity for us to discover some things that might be important in terms of some of the evils that are out there in the world. So let's see what we have and let's get started on this. Appellant Jade Sanders and Lamont Thompson were tried before a jury. Both appellants were found guilty of the malice murder of their infant son, Crown Shakur, by failing to seek necessary and adequate medical attention for him, and involuntary manslaughter during the commission of reckless conduct by depriving their child of necessary sustenance, which was a lesser included offense of second malice murder count. Appellants were also found guilty of 2 counts of felony murder during the commission of cruelty to children in the first degree, and 2 separate counts charging those underlying offenses. One child cruelty count charged the appellants willfully deprived their child of necessary sustenance to the extent that his health and well-being were jeopardized, and the other child cruelty count charged that the appellants maliciously caused the child's cruel and excessive physical and mental pain by failing to seek necessary and adequate medical attention for him. Treating the felony murder verdicts as surplus, the trial court entered judgment on the conviction of the malice murder verdict, merged the remaining counts, and sentenced both the appellants to life imprisonment. Appellants filed separate motions for a new trial. The trial court denied Thomas's motions, but granted Mrs. Sanders' motions based on ineffective assistance of trial counsel only as to the charge of malice murder, finding that because counsel's deficient performance, there was a reasonable probability that the jury would have returned a different verdict on malice murder as to Ms. Sanders, but not on the remaining counts. Thereafter, the trial court vacated Ms. Sanders' malice murder conviction, entered new judgment on the conviction only of the first felony murder verdict, and again sentenced her to life imprisonment. Separate notices of appeal were filed. We dismissed Thomas's original appeal, and his motion for a new trial was untimely and did not toll the time for filing notice of appeal. However, he was subsequently granted an out-of-time appeal and then filed a notice of appeal. The 2 appeals are consolidated for disposition in this original opinion. Construed most strongly in support of the verdict, the evidence shows that appellants were vegans who fed their baby only soy milk and apple juice. When the victim was approximately 6 weeks old and weighed 3½ pounds, appellants took him to the emergency room, claimed the child was well until a few minutes earlier. However, the victim was essentially extremely thin and emaciated, with skin and bones appearance and ribs which could be easily seen. He was dirty and wearing a diaper with dried excrement on it. He was not breathing and had no heartbeat, and was very dehydrated and cool to the touch. The hospital staff was unable to resuscitate the victim. Unlike most parents with a child in critical conditions, appellants were unemotional. At trial, Thomas volunteered that the food for baby was very expensive, and Miss Sanders admitted that she had not told the care workers about her pregnancy. Extensive medical testimony showed the victim's need of medical attention and his condition of extreme malnourishment or starvation was not caused by cystic fibrosis, since the victim did not have that disease, which included the absence of subcutaneous fat and the process of cannibalization by his own body, and which, regardless of any disease, caused his death. The expert testimony showed the victim would have had the same general appearance for at least a week prior to the death. The medical examiner testified that the victim did not suffer from the most common forms of metabolic disorders typically associated with sudden infant deaths, did not show signs of digestive abnormalities, and was unable to fight infections because of the advanced state of the malnutrition, which led to a disease resulting in his death, and would have been able to recover if he had been provided with the proper nourishment and antibiotics. Ms. Sanders argues that circumstantial evidence was insufficient to support the verdict against her and to prove the requisite intent. She is ultimately convicted of felony murder during the commission of child cruelty in the first degree. A parent, guardian, or other person supervising the welfare of having an immediate charge or custody of a child under the age of 18 commits the offense of cruelty to children in the first degree when such a person willfully deprives the child of necessary sustenance to the extent the child's health or well-being is jeopardized. Sustenance is that which supports life, food, victuals, and provisions. Our statutes in use of the word sustenance means necessary food and drink, which is sufficient to support life and maintain health. Evidence presented by the defense regarding applicant's conduct and intent was thoroughly contraindicated. The testimony presented by the state showed that the infant victim obviously was not fed enough, and that neither disease nor mere choice of nutrition by appellants for victims could have left him in the extremely malnourished condition. The evidence was not purely circumstantial, as numerous medical professionals who observed and treated the victim testified as what they saw. Direct medical testimony revealed that the victim was severely malnourished and that his health was jeopardized. Whether Ms. Sanders willfully perpetrated the act was an issue for the jury to resolve. Under the laws of the state, a person is not presumed to act with criminal intent, but the trier of facts, the jury in the present case, may find such intention after consideration of conduct and demeanor of the defendant and all other circumstances connected with the act for which the defendant is charged. The question of criminal intent is for the trier of facts. So, as you would expect, the issue of criminal intent is a factual question. Did this person have the requisite mental state? And did they commit the act? Did they have the mens rea? And did they have the actus rea? These are questions for a jury. And in order to present this question to a jury, you present all the relevant facts, all of relevant context that you think is relevant. Both sides argue, and the jury is left to decide the question. Did they have the intent? Did they commit the act? This jury says yes. Fine. Sorry about that. The evidence was sufficient for a rational trier of fact to find Ms. Sanders guilty beyond a reasonable doubt of child cruelty charge, which was the predicate offense for a conviction of the felony murder. Although Thomas does not contend the evidence was insufficient to support malice murder conviction, we note that, like willfulness, malice is a state of mind and frequently must be proven indirectly. Whether a child has been starved, neglected, and abused with malice so as to constitute murder, or has been merely harmed as a result of inability, carelessness, or accident, may often require considerable indirect proof to prove determined state of mind. Reviewing the evidence in the light most favorable to the verdict, we conclude it was sufficient to authorize a rational trier of fact to find beyond a reasonable doubt that both appellants were guilty of the crimes for which they were convicted. So we note here the standard of review. We often see in cases when we're looking at interlocutory appeals and other things where the court will say, well, we'll view it in the light most favorable to the other side, right? So you'll often see where they'll say, we're assuming the facts in the light most favorable to the non-moving side, like a summary judgment motion. We're assuming everything is contra and still saying if we can reach this conclusion. But here, that's not the right standard because a jury has already reached a decision. A trial has reached a decision. So now we're reviewing evidence in the light most favorable to the verdict. The jury has reached its conclusion. Now the question is, in the light most favorable to what the jury concluded, can they reach the conclusion or not? And they're saying that they can. Seems perfectly reasonable so far. Ms. Sanders concludes that the prosecutor engaged in prosecutorial misconduct when he elicited testimony during cross-examination which invaded the jury's province and commented on the ultimate issue. However, neither appellant made the objection at line at the time of testimony. Therefore, appellate review on this issue has been waived. The contemporaneous objection rule cannot be avoided by characterizing trial occurrences as example of prosecutorial misconduct. So, as it indicates here, typically you have to object at the time something occurs. If you don't object, you lose it. And there are a lot of tactical reasons an attorney might not want to object. So it's not necessarily error. It's not necessarily misconduct for an attorney not to object because it depends on a bunch of tactical considerations. So if we're going to an issue of attorney malpractice, we'd have to analyze that as to whether or not a reasonable attorney could take that course of action or not. So that's one of the things we're talking about there. Thomas's untimely motion for a new trial raises a claim that trial counsel rendered ineffective assistance of counsel by failing to call a forensic expert at trial. The same claim is raised in Thomas's sole enumeration of error in appeal. Although Thomas did file a notice of appeal within 30 days, that motion was void because they did not file it within 30 days of the entry of conviction. Therefore, we affirmed in the case because it was the only alleged error. However, appellate counsel never filed the motion. The fact that this denied Thomas's motion for a new trial prior to granting the untimely appeal does not preclude him from filing a second motion for a new trial raising the issue of ineffective assistance of trial counsel. The failure to file a valid motion for a new trial raising the claim of ineffective assistance of trial counsel bars review for claim at this time. Again, certain things have to be brought within certain windows of time. There's procedural due process. And as the term procedural due process suggests, you're entitled to a particular procedure that is set out in terms of these things. So that's what they're talking about there. Ms. Sanders also contends that her trial counsel was ineffective in several respects. In order to succeed on a claim of ineffective assistance, Ms. Sanders must prove that her trial counsel performance was deficient and there's a reasonable probability the trial result would have been different if not for the deficient performance. In reviewing the trial court decision, we accept the trial court's factual findings and credibility determinations unless clearly erroneous, but we independently apply legal principles to the facts. The trial court gets to determine the facts, the appellate court gets to determine the law. This is very familiar to us. Ms. Sanders first argues that her trial counsel failed to obtain and provide any independent medical expert testimony at trial to refute the findings of the state testimony as to cause and manner of death. The trial court found that failure of the attorney to investigate the medical evidence thoroughly and summarily reliance on the lawyers of one inadequate efforts constitutes deficient performance. Counsel for Thomas did consult with one potential medical expert who had previously testified for defense regarding cystic fibrosis in a very similar case, resulting in acquittal. Thomas's lawyer rejected the use of that expert for strategic reasons, either because he would not come across well the jury or because he could not reach the same conclusion in this case. Thus, it is not clear that the performance of Thomas's trial counsel was deficient. However, for the purposes of appeal, we predetermined the issue of whether the trial court erred in concluding that Ms. Sanders' lawyer was deficient in relying on the investigation of Thomas's attorney. So was it a mistake for the one attorney to rely on the investigation of another attorney instead of conducting their own analysis is the question that they're trying to apply here. Before applying the prejudice prong of the Strickland test to the assumed deficiency, we note Ms. Sanders' further argument that her trial counsel failed to investigate, interview, and call 3 family members and a friend to refute the state's allegations that she had not revealed her pregnancy to others or care for the baby properly. The trial court found that Ms. Sanders' attorney was deficient in this respect as well because he failed to consider presenting any witnesses other than those who had seen the baby, and he relied on her to suggest witnesses even though she seemed depressed and had no prior experience with the criminal justice system. However, determining whether trial counsel was deficient in failing to obtain the testimony of Ms. Sanders' friends and family, we turn to the trial court's determination that although there is a reasonable probability that medical expert testimony and additional lay witnesses would have changed the outcome on the malice murder charge as to Ms. Sanders, she failed to demonstrate a reasonable probability that such evidence would have resulted in a different verdict on the remaining charges. So it might be error with respect to some charges, but not with respect to other charges. So we're looking to each and every charge on its own merits as to determine whether the attorney made a mistake. Fair enough. In its order on the motions for the new trial, the trial counsel extensively reviewed both medical testimony presented to the state at trial and testimony of Dr. Jerry Bush, who was presented by Ms. Sanders as hearing on the motion for the new trial. Dr. Bush, who's an expert in internal medicine, testified that because of colonization of a certain type of bacteria in the victim's system, there is a reasonable probability the cause of death was cystic fibrosis, which causes malabsorption of nutrients from the small intestine. However, the state's medical testimony showed the symptoms of cystic fibrosis include diarrhea, vomiting, bowel obstruction in an infant by a particular kind of plug, and respiratory problems, none of which were shown by any evidence at the trial to have been present in the victim. Moreover, the trial court specifically relied on the fact that Dr. Bush conceded that cystic fibrosis is a treatable condition, and this child could have been treated for cystic fibrosis, and part of the suitable treatment would have been to increase the amount of nutrition provided to the child. In pertinent part, the trial court found as follows. The photographs that depict the victim shortly after his death constitute compelling evidence that Miss Sanders must have been aware the baby was failing to thrive. In addition, the medical testimony regarding how the baby would have acted in the weeks immediately preceding his death was not contraindicated by Dr. Bush's testimony. This testimony makes it very difficult for a jury to believe the parents' account that the baby looked and acted fine right up until just before they brought him to the hospital. The court is not persuaded that testimony from fans, friends, and family about Miss Sanders' pleasure regarding the child would have been reasonably likely to overcome the photographic and medical evidence about the baby's apparent condition. After all, the jury reached the guilty verdicts on all charges, despite hearing testimony from Thomas's relatives regarding the trip to see them. Indeed, lay testimony from 4 persons in questions would have been weaker than the cumulative testimony on both behalf of appellants by mother and sister that appellants had visited them in Kentucky when the victim was 1.5 weeks old, and that both appellants were happy to see the baby, were protective of him, fed him well, and took good care of him. We conclude the trial court did not err in finding that Ms. Sanders failed to demonstrate a reasonable probability that, but for the alleged errors of her trial counsel in failing to investigate and call medical and lay witnesses, the jury would have reached a different conclusion on other charges other than malice murder. So again, showing the standard that has to be reached. The jury has reached its verdict, and in determining if the lawyer committed error, we're trying to determine if it's reasonably probable that but for these errors, it would have made a difference. If it doesn't make a difference, then it is considered a harmless error as to the conviction, because it would have come out the same either way. Ms. Sanders also asserts that her trial counsel was ineffective in failing to object to 2 instances of expert testimony regarding the cause of death as invading the jury's province and commenting on ultimate issue. The first instance, which is also subject to a separate enumerated discussion in Division 2, after a neonatologist was cross-examined with respect to prematurity and low birth weight not being the mother's fault, the prosecutor immediately asked him on re-examination where if the mother doesn't take a child to a doctor after it's born, though, and the child died if that's the fault of the mother, and the witness answered affirmatively. In the second instance, the medical expert testified that she determined the matter of death to be homicide because she felt the malnutrition was due to failure to provide sufficient care by caregivers. Neither witness testified the appellant was guilty of the charges against them in a legal context. In this context, the experts were giving scientific conclusions within the fields of expertise regarding the etiology of the baby's condition based on hypothetical or based on inferences drawn from medical evidence, and therefore those conclusions were beyond the ken of an average juror. Ms. Sanders also complains of her attorney's failure to make objection and move to strike the entire testimony of a pediatrics professor because he alluded to the fact that he testifies for the prosecution when he feels the accused is guilty. Actually, when testifying that his services in various cases have been procured by both prosecution and defense, the witness also gave confusing testimony that is not called to court very often when defense cases because either I'm thinking the person's guilty or they're innocent and then we don't go to court. The testimony did not associate the procurement of the professor's services by a prosecution with guilt or innocence of the defendant. Thus, contrary to Ms. Sanders' argument, the testimony neither invaded the province of the jury nor constituted a comment on her credibility or her guilt. Moreover, an objection by Thomas's attorney effectively stopped any further testimony on the topic. Under these circumstances, we conclude that if a motion to strike had been made, striking the entire testimony of the witness would not have been required, and the absence of such a motion or additional objection was not harmful. Therefore, Ms. Sanders' lawyers was clearly not ineffective in failing to make the motion to object or objecting to this or moving to strike. Ms. Sanders finally argues that her trial counsel is ineffective in conceding throughout direct examination Ms. Sanders that she apparently did not feed her baby either enough food or the right kind, in arguing to jurors that her mistakes in caring for a child authorized them to find her guilty of involuntary manslaughter, and conceding during argument, although she told police that she had performed CPR on her dead baby in the hospital, that the emergency room physician was completely honest in testifying no one would ever be allowed to perform CPR on a dead infant. However, the admissions by Ms. Sanders' attorneys of mistakes on her part were consistent with appellant's joint theory of defense that the parenting mistakes constitute involuntary manslaughter but not murder. So basically, Ms. Sanders' argument here is she's conceding a whole bunch of ground in the hope that she can prove a lesser charge. So obviously there's some danger in that kind of argument because you're giving evidence to the state by the concession, but at the same time the idea is that you're building credibility with the jury by conceding certain ground in the hope of getting a lesser charge. And apparently it was part of their trial strategy. So as long as defendants were aware of this and conceded to it, no error on the part of the attorney from saying, yes, I'll concede to this ground in the hope of getting this result rather than this result. It didn't work, but it's not malpractice. The theory was reasonable given the strong evidence that the victim was malnourished for days to weeks, during which he was unable to respond normally to stimuli, and then he needed medical attention. After hearing the evidence presented and observing the effect of medical witnesses, some of whom wept during their testimony, Ms. Sanders' lawyer made the partially successful strategic decision to mitigate damage to the defense by showing the jury that it could convict her of a lesser included offense of involuntary manslaughter. Defense counsel is not deficient in adjusting his strategy to meet development at trial. Fair enough. As things progress in the trial and you're reading the room, you got to adjust to this reality. So if, the medical experts are weeping on the stand, you might want to consider an alternate course of action other than we're just not guilty. Fair enough. The fact that in hindsight, appellate counsel would have advanced a different theory at trial than that of trial counsel does not amount to a showing of ineffective assistance. Justice affirmed, all the justices confirmed. So that is the end of the case of Sanders versus the state of Georgia, in which a woman who apparently was a practicing vegan insisted on feeding her child using only vegan kinds of things. So didn't feed her child anything that wasn't a non-vegan product, including presumably breast milk or other nutritional supplements that would have had non-vegan aspects to it, only giving the child vegan type things, and the child slowly wasted away and died, and they both were found guilty and sentenced to jail for the rest of their lives. And I, of course, have zero objection to that because they have an affirmative duty to care for their child. Most of the time, people do not have an affirmative duty to each other. If I see someone who's laying in the street, who's suffering, I have no particular duty to them. And if I choose not to help them, I'm not responsible to them. However, for very obvious reasons, a parent does have affirmative duties to their child. And if that child suffers, the parent is on the hook for not caring. And that seems to be the case here. And according to the medical testimony, when they arrived in the emergency room and their child was dead, they perceived to apparently not care. So, not the greatest people in this world, and they're in jail for the rest of their lives. And some justice, at least, was done in this world. But unfortunately, it came at the expense of a dead child. And that is part of the sad reality of life sometimes. Not everyone is super nice. So that is the end of our discussion of Sanders versus State. Okay, kids. That was depressing story number 1. We're about to go into depressing story number 2, just FYI. What's worse than child murder? It's not good. Our next case deals with United States of America versus Kyle Adam Kirby. This case deals with a cop who decided that it was a good idea to maintain possession of child pornography on his work-issued computer. This did not end well for him, and we're going to discuss this in terms of the sentence that he was prescribed. So let's give this a quick read and see what this guy did and the sentence that he was given in terms of that. This appeal requires us to decide whether the United States sentencing guidelines cap on an otherwise recommended sentence of life imprisonment at 470 months when the statute of convictions does not allow a sentence of a life term. A jury convicted Kyle Adam Kirby of 5 counts relating to the production and possession of child pornography. At sentencing, Kirby's total offense level was 43, which incidentally, under the sentencing guidelines, is the highest offense level possible, which means that the guidelines ordinarily recommend a sentence of a life term. But because the statutory maximum punishment for Kirby's crimes was less than a life term, the district court concluded that the guidelines' recommendations of consecutive terms of the maximum sentence for each of the appropriate convictions. So we have two different things going on. We have the statutes, which say a range of possible sentences. How much time can you possibly sentence someone for? Sometimes there's a minimum and sometimes there's a maximum. There's some kind of range in the statutes. And then we have the sentencing guidelines. These are auxiliary that sit outside the statutes, but basically say, given your prior history, your prior criminal history, and given how many seriousness of this current crime, it suggests a particular range of sentences that are appropriate. And courts normally stick to this guideline. Now, this guideline used to be mandatory. Courts had to give a sentence within this guideline, but the Supreme Court about a dozen years ago found the requirement unconstitutional because the Supreme Court essentially said that every case has to be heard on its own merits. So now the guidelines are kind of merely strongly suggestive. The courts can deviate from the guidelines either in excess of them or in lower of them, as long as it has some sort of rational basis that it explains in its decision. But in any case, you can't go beyond what the statutes allow. So in this case, the guidelines said it recommended a sentence of life imprisonment, but the criminal offenses did not allow for that possibility. So you can't give more than statutes allow. So in this case, what the court did was it said, okay, well, since the guidelines say I should give a life sentence, but I can't, what I'm going to do is I'm just going to max out everything I possibly can, issue consecutive terms, and that will get me as close as I can. Well, how close? The district court then adopted this recommendation and sentenced Kirby to 1,440 months of imprisonment, which for those of you keeping track at home is 120 years. So I'd argue that's pretty close. Kirby argues the correct sentence is 470 months of imprisonment because the United States Sentencing Commission equates life sentence to that term for statistical purposes. He also contends his sentence was substantially unreasonable, and we disagree and we affirm Kirby's sentence. State and federal law enforcement officers traced 28 video files and 90 images depicting child pornography to the Internet Protocol address of Kyle Adam Kirby, a sergeant with the Live Oak Police Department. A later investigation by the FBI uncovered over 200 images of children being sexually abused on the laptop computer assigned to Kirby's patrol vehicle. He stored the child pornography on his work laptop, and he's a cop. So just, all kinds of special. Kirby, who then for some reason was suspended from his job, responded by asking Sergeant Derek Slaughter to erase files from his account on the department desktop computer. Instead of deleting the files, Slaughter searched Kirby's account and found images of a nude prepubescent boy. So he was suspended from his job for some reason unrelated to this. He said, please delete all my files. And he said, let me not do that. Let me look at the files. And he did. And we found child pornography. So excellent. Slaughter reported the image of to the police chief, who approved a search of the computer. A forensic analysis of the computer produced at least 80 images of child pornography or child erotica. Most of these images were of Kirby's 13-year-old stepdaughter, either captured by hidden cameras in bathrooms or taken while Kirby was assisting his stepdaughter with stretches due to a sports injury. The computer also contained a pornographic image of a friend of Kirby's stepdaughter. So just to add that little extra step, It was of his own stepdaughter, the child pornography. So just super fantastic. So for those of you keeping up with the fact pattern, we've got images of child pornography of his own stepdaughter that were stored on his work computer. And once again, he's a cop. So that's just great. A grand jury charged Kirby with 3 counts of sexual exploitation of children for the purposes of producing child pornography, and 2 counts of possessing with intent to view material involving minors engaged in sexually explicit conduct. Following the trial, a jury found Kirby guilty of all counts. Using the 2016 edition of the United States Sentencing Guidelines, the probation officer assigned Kirby a total offense level of 43, which again is the highest level possible, and a criminal history category of 1. The district court accepted this calculation without objection from either party. As the district court explained, the guidelines ordinarily recommend a life sentence for this offense level. But because none of the counts of the conviction allowed for life imprisonment, the district court concluded the guidelines recommendation, taking the maximum for each count and adding them together for the sentence. And again, without objection, the district court then calculated the guideline sentence as 1,440 months. After considering the statutory sentencing factors, the district court sentenced Kirby to the 1,440 months of imprisonment. We review the interpretation of the sentencing guidelines de novo. We review the substantive reasonableness of the sentence for abuse of discretion. So there they say when you're looking to the judge and what they do in terms of what is reasonable, it's abuse of discretion, which is a pretty high standard. So the trial judge gets quite a lot of latitude as long as it's within the statutory limits. We reverse for abuse of discretion only if we're left with a definitive and firm conviction that district court committed a clear error of judgment in weighing the factors by arriving at a sentence that lies outside the range of a reasonable sentence dictated by the facts of the case. For the first time on appeal, Kirby argues the district court committed procedural error by calculating the guideline sentence as consecutive terms of the maximum sentence for each count of conviction. As a fallback position, he contends his sentence was substantially unreasonable. We address each argument in turn. Kirby argues for the first time on appeal that district court incorrectly calculated the guideline sentence. His failure to object in district court would ordinarily mean that we review for plain error, but because no error occurred, we need not decide whether the alleged error occurred or whether it was plain or effective rights. As Kirby concedes, his total offense level and criminal history category would ordinarily call for life imprisonment, but none of Kirby's offenses call for a life sentence. Look at the statute, which imposes a maximum sentence of 30 years, and look at the other statute, which imposes maximum sentences of 10 or 20 years. So that is what we got. We got multiple counts of sentences, and the limits in them are 30 or 20 or 10 years. Okay. So the district court applied a section of the guidelines which explains what to do in this circumstance. If the sentence imposed on a count carrying the high statutory maximum is less than the guideline Sorry. Let's try that again. So the district court applied the section of the guidelines which explains what to do in this circumstance. If the sentence imposed on the count carrying the highest statutory maximum is less than the ordinary guideline recommendation, the sentence imposed on one or more of the counts shall run consecutively, which means one after another, but only to the extent necessary to provide a combined sentence equal to the guideline recommendation. The parties agree that this section controls our decision. They dispute what sentence is equal to a life imprisonment. The district court adopted a straightforward understanding of a life sentence, that is, indefinite in duration. So it concluded that the guidelines recommendation of consecutive terms of statutory maximum for each count of the conviction, the closest sentence to life that the law would allow. The maximum term for the 5 counts of conviction collectively produced a sentence of 1,440 months of imprisonment, but Kirby contends a life sentence converts to 470 months. He explains that the Commission defines a life sentence for statistical purposes at 470 months, a length consistent with the average life expectancy of federal criminal offenders. The district court correctly interpreted the guidelines. The language of the guidelines, like the language of the statute, must be given its plain and ordinary meaning. And the meaning of a life imprisonment is clear: confinement in prison for the remaining years of his or her natural life. By definition, life imprisonment lacks a fixed term. So the district court correctly combined the statutory maximum for each count of the conviction to send Kirby's guidelines to 1,440 months of imprisonment, the closest available sentence to indefinite incarceration. The definition of life imprisonment in a statistical sourcebook published by Sentencing Commission does not alter this conclusion. To start, the statistical sourcebook is not part of the sentencing guidelines. The Commission publishes the sourcebook based on its authority to collect and publish data on the sentencing progress. The report also satisfied the Commission's obligations to provide an annual report of sentencing data to the United States Attorney General. But the sourcebook does not amend or redefine the guidelines in any way, which would require the Commission to approve it by an affirmative vote and submit it to Congress for review. As the First Circuit held, though 470 months may be an accurate statistical summary and representation of the length of many life sentences, and may be indeed equivalent to a life sentence in many individuals, there is no cap within the guidelines that limits life sentences to 470 months. And although one circuit has approved the use of 470 months as a baseline to calculate a reduction in sentence for substantial amount of assistance to the government, no circuit has defined life imprisonment as 470 months. The Supreme Court has defined a life sentence as the second most severe punishment known to the law, and we cannot accept Kirby's invitation to hold that a 1,440-month sentence is worse. We instead conclude that when the sentencing guidelines recommend life imprisonment, they mean life imprisonment. Accordingly, the district court did not err procedurally when it calculated the guideline sentence so as to close to the indefinite incarceration as the law allowed. Kirby also contends his sentence is substantially unreasonable, which requires him to establish the district court failed to afford consideration to relevant factors that were due significant weight, give significant weight to improper or relevant factors, or commit a clear error of judgment. Substantively unreasonable sentences are rare, and they are. The appeal courts are not prone to overturn things that are within the judgment of the lower courts, unless they're outside the bounds of reasonableness. And they have to be pretty unreasonable at that, too. We also ordinarily expect a sentence within the guidelines range to be reasonable. As an initial matter, Kirby's argument is largely predicated on the erroneous conclusion that the district court imposed an above-guideline sentence. Regardless, the sentence was not unreasonable. Before imposing the largest sentence it could, the district court thoroughly discussed Kirby's particular heinous conduct and direct participation in the creation of child pornography, his breach of public trust as a police officer, and his total failure to take responsibilities for his actions. We see no abuse of discretion, and we affirm the sentence. So that is the end of the story of Kyle Adam Kirby. Now, I will give one item of good news for Mr. Kirby, out there. Unfortunately, the United States federal government long ago abolished parole. Parole is no longer a thing in the United States federal system. However, one item of good news is that you can get credit for good behavior in court and good behavior in jail. It's meant as an incentive to help encourage people to behave better. So you can get some good time credit, and you can get up to 15% of your time credited. So he may not have to serve 120 years. He may only have to serve 85% of that. So that would be, let's see, that'd be roughly minus 20 years. So he may only have to serve about 100 years of the 120 years of his sentence. So, hey, there's one item of positive news. So if he's really, really good, maybe he'll get out sometime around the year 21, 22, if I did my math in my head correctly. So we'll see what happens when that date rolls around. For our next case, we are going to cover a story discussing Jonathan Vanderhane. He was recently found not guilty by a trial court for allegedly doing crimes. Let me try that over. Start over that. For our next case, we're going to discuss the story of Jonathan Vanderhane. Jonathan Vanderhane was charged with crimes relating to criticizing a judge, but fortunately, he was recently found not guilty by a jury. So we're going to read this original article from Reason, and then we're going to read the follow-up article discussing the not guilty verdict so that we can understand what is going on and we can analyze the law accordingly. So let's discuss the case of Jonathan Vanderhane. A Michigan man was jailed last month on a $500,000 bond after writing critical posts on Facebook about a judge who denied him custody of his son. Jonathan Vanderhane, who is 35, is now standing trial for malicious use of telecommunication services. The saga began 2 years ago when Vanderhane petitioned Macomb County Circuit Judge Rachel Reschino for sole custody of his 2-year-old son, Killian. Vanderhane argued that Killian's biological mother was unfit to be Killian's sole guardian. Judge Rencino disagreed, and the child's mother was able to retain custody. Shortly after the custody dispute, Killian passed away in his mother's care from what authorities concluded was a pre-existing medical condition. Despite that conclusion, Vanderhey believes that Killian would still be alive if he had been granted custody. Since his son's death in 2017, Vanderhey has used his Facebook page to criticize the custody ruling. Those posts, none of which were deemed threatening by a police department that investigated him, landed Vanderhey in jail. According to the complaint and an emergency bond hearing provided to reason by Vanderhey's lawyer, Nicholas Somberg, Vanderhey was charged with one misdemeanor count of malicious use of telecommunication services due to his criticism of the judge. The definition of malicious use includes using a telecommunication service with intent of terrorizing, intimidating, threatening, or harassing the judge. The case filed out by Sergeant John Conklin of Macomb County Sheriff's Office notes that Racino was made aware of Vanderhey's posts, several of which include screenshots of her own Facebook page and pins on Pinterest. The screenshots are accompanied by captions promising to expose corruption of the court system and calling the judge and Mary Duros, a 14-year friend of the court who was involved in the custody case, shady. At no point does Vanderhey threaten harm or violence towards either the judge or Duros. Copeland took various screenshots of Vanderhey's Facebook posts, including the following. So now we got a paste. We got a guy's image. It says, families of corruption, the misuse of public power by elected politician or appointed civil servant for private gain. Okay? And then he says, data be back to dinging, and you best believe I'm going to dig up all skeletons in this court closet. I see no problem with this under First Amendment principles. The Facebook post in question shows Vanderhey holding a shovel with photoshopped initials RR and MD, believed to be the judge and Duros, respectively. The caption says, data back to digging, and you best believe I'm going to dig up all the skeletons in the court's closet. The post was published to Facebook on July the 8th. Somberg explains the reason that the day of the particular post should have jeopardized the case brought by Vanderhey. Vanderhen received a letter from Sergeant Montefiore dated July the 10th informing him there's a warrant for his arrest for malicious use of telecommunications. The letter said his actions occurred on or about July the 7th. Vanderhey was arraigned before the Macomb County District Court on July the 11th. Vanderhey was released on a $10,000 bond under the condition that he would not engage in direct or third-party contact with the judge. Vanderhey was also prohibited from sending inadvertent messages by way of Facebook to the judge. Following the arraignment, Vanderhey continued to use Facebook to post about his son's mother, and his case, topics Somberg argues are not in violation of the bond conditions. Regardless, Vanderhey was summoned to appear before the district judge at the end of July for an emergency bond hearing for allegedly posting messages about the judge. A list of exhibits presented to the court highlights Facebook posts calling his son a hero, criticisms of the son's mother, and criticisms of the system, none of which directly reference the judge. So I would agree he's not in violation of the order. The only reference to the judge is found in Exhibit 1, which features screenshots of Vanderhey's July 8th Facebook post. Considering Vanderhey did not receive his bond conditions until 3 days later, after the Facebook post was published online, its inclusion seems like an inappropriate attempt to paint Vanderhey as more of a threat than he actually is. In a transcript of the exchange between Somberg and the judge at an emergency bond hearing, Somberg argues that Vanderhey has a First Amendment right to air his court-related grievances online. Every one of these exhibits are innocuous, are irrelevant, are not threatening, are not harassing, are not intimidating in any ways whatsoever. And I would make the argument that he can say, F the judge, F the President of the United States. I mean, you have the right to say that stuff. Cito responded that there are limits to the First Amendment right of freedom of speech. The court. There cannot be anything of a threatening nature. You cannot yell. There used to be an example, the famous case. You cannot yell fire in a public place or movie theater. Something like that. Way to butcher it, Judge. That's just great. We're talking about threatening a circuit court judge is an ordinary allegations against Mr. Vanderhey. When there's no conduct, it's no contact directly, indirectly, or social media. These, although he likes to hint around the fringes of it, in my opinion, are of a threatening nature after no conduct was in place. I tell you what, guys, if you can find the threat in any of this, you are smarter than me because there's nowhere anything even remotely close to a threat in this. And I'd also like to take note that apparently, according to the court's own logic, apparently now I'm threatening the court because I'm criticizing the court. I'm now making an observation that's criticizing the court, which apparently in the court's reasoning somehow constitutes a threat. I don't know how it constitutes a threat. I'm not making a threat. I'm not implying a threat. I'm critiquing the court, which, is something that I thought I had the First Amendment right to do. But apparently, according to the court's logic, this is somehow a threat, even though it's clearly not, because there's nothing that any reasonable observer could perceive as a threat, because I'm not threatening the court. I just think they're a bunch of idiots. Somberg then asked Lucida to explain why other posts were considered threatening towards the judge. Lucida told Somberg that the Facebook posts speak for themselves. You can sit there and read every one if you want them, but they're already part of the record. Mr. Somberg, I understand that, Your Honor, but you just said you found the exhibits to show they're threatening in nature. I'm just asking what the court is threatening about them. The court, because they're alluding to Judge Racilio. I'm not going to sit here and explain it any further, because here's what I'm reading, and here's also what I put in lean. Do not harass, intimidate, beat, molest, wound, stalk, threaten, or engage in any conduct that would place any of the following persons or child of any of the following persons in a reasonable fear of bodily injury: spouse, former spouse, individual with whom the defendant has a child in common, resident or former resident of the household. Do not assault, harass, intimidate, beat, or wound any of the following persons. The judge. And in my opinion, he violated that. In my opinion, he came nowhere anywhere remotely close to that. And further, in my opinion, this court is a complete and total idiot. And this court doesn't understand the first goddamn thing about the First Amendment, which more than a little bit irritates me, because you would think the court would understand the First Amendment, but apparently not so much for some reason. And once again, everything I'm saying is protected opinion, court, so, bug off. People have a constitutional right to express opinions about government officials, including judges. Yeah, no doke. Defendants who appear before the judge have the right just like anyone else. It may not be wise to criticize the judge hearing your case, but it's a right defendants have if they want to exercise it. Yes, they do. Capital notes that free speech does not include the right to make what the law calls true threats to inflict bodily harm, including judges. That's true. You cannot make true threats. That's 100% true. You cannot make true threats. Is anything he said even remotely close to a true threat? Not even remotely close. Not even remotely close. I can't believe a judge said anything like this. It's hard to fathom. Yet Conklin, the investigating sergeant in Vander Hey concluded at no point does Vander Hey threaten harm or violence towards the judge or Duras. Not only does it appear that Vander Hay's First Amendment rights have been violated, the judge also increased the bond to $500,000, raising questions about the use of excessive bails as means of further punishing and suppressing speech. This judge just sounds like a real piece of work. I honestly hope this judge gets thrown off the bench. I really, really do. This is a total abusive process, and this judge is unfit to serve. Totally unfit to serve. In emergency appeal, Somberg argued legal precedent says that bail is excessive, incident amount greater than reasonably necessary to adequately assure the accused will appear when his presence is required. The nature of the offense, Somberg concludes, also raises questions about whether the $500,000 bond. Vander Hey was charged with a misdemeanor that carries a maximum sentence of 6 months and a maximum fine of $1,000. Okay? He was charged with an offense that carries a maximum sentence of 6 months and a maximum fine of $1,000, and for this, the judge gave a $500,000 bond. That seems a bit disproportionate to me. Somberg can see no logical explanation for the court's decision to increase the bond 50 times the initial amounts. Vander Hey has no criminal record, nor is he a registered firearm owner. Not sure how that's relevant either. There's a constitutional right to have a firearm, so, These factors, Somberg argues, would justify a lower bond, not a higher bond. In a statement to Reason, Somberg likens the high bound to intimidation. He's never threatened anyone, has no criminal history, and has no flight risk. $500,000 cash bond is what you'd expect for a murderer or rapist. I can't think of any reason to see such an astronomically high bond other than to intimidate and punish him for speech. We're fighting this case not just for my client, but to defend the rights of us all. So this is just irritating me beyond limits that I didn't know I had. So let's read part 2. Part 2. So this happened 2 days ago. A Michigan man hasn't been acquitted by a jury for criticizing a county judge on Facebook. It took a jury 26 minutes to decide that he was not guilty. 26 minutes? That seems a little long. I reached that conclusion a lot faster. According to Jonathan Vander Hey's lawyer, it took a jury all of 26 minutes and 8 seconds to decide that he was not guilty of using a Facebook account to threaten a county judge. Reason previously covered the Michigan father's free speech case, which began with the child custody 2 years ago. And then we covered the fact that about this custody issue we already discussed, and that happened relative to a pre-existing medical condition. The judge was made aware of the post and the investigation was open towards Vander Hey. At no point did he threaten harm. Nevertheless, he was charged with malicious use of a telecommunication device. Malicious means Vanderhay was accused of using a telecommunication service with intent of terrorizing, intimidating, threatening, or harassing. None of those things are even remotely close. Prosecutors and presiding district judge Sebastian Lucido used the following post to accuse Vanderhay of violating bond conventions. The same post. Guys, look at this post. I ask you, how is this qualify as terrorizing, intimidating, threatening, or harassing? When you say the misuse of public power by a public elected politician or appointed public service for private gain, data bring back to digging you, and you best believe I'm going to dig up all the skeletons in this court closet. In other words, I'm going to expose you for corruption. How is that threatening? It's not. I'd also like to point out that he kind of succeeded a little bit in his goal, thanks to your own incompetence. You basically exposed yourself as being corrupt. All of you. I can't believe the judge who was in judge of this trial, or the prosecutor brought this forward. So, like, we have the original judge, we have the person arresting him, we have the trial judge, and we have the prosecutor, all of whom are pressing this case. And they're all like, it's all horrible. They all need to be thrown out. There's nothing even remotely close to malicious threats. It's irritating me. All these people need to be thrown out of the cool kids club of attorneys. They all need to be disbarred and or thrown off the bench. It's just unbelievable. A jury acquitted Vanderhay on Thursday of the charge. Thank goodness for that. Sonnenberg told me he was so happy justice was served both for Vanderhay and his son. He used a portion of his closing argument, which provide to reason, to remind the jury the case was first and foremost about the First Amendment right. Our founding fathers guaranteed the right to trial juries for situations just like this. Yeah. The founders understood that absolute power corrupts absolutely, and we should be judged by a jury of our peers, not the government. You should all feel lucky to be sitting for such an important trial. The verdict you come back with will send one of two very different messages to the people of Macomb County. We either have the right of freedom of speech, or if the people of Macomb criticize our elected officials, they better watch out. Yeah. Vanderhay also provided a statement that he's beyond thankful to be a free man. He also thanked Sonnenberg for his work on the case. The past 2 months have been incredibly hard, but was a journey I was willing to take voice when my son needed it most. Hearing of everyone's support while I was locked up is what kept me going, and most importantly, kept Killian's spirit alive. I know he's smiling down proudly and feeling like the most special boy in the world. Well, this is super, super irritating. I am super, super irritated by this, and I sincerely hope in my deepest heart of hearts that all the judges we just spoke of are thrown off the bench. I sincerely hope that their bar licenses are revoked. They engage, and I hope the prosecutor's license is revoked too. They all engage in what appears to be, in my judgment, a massive abuse of process. You know, justice has to be done, and justice has to seem to be done, and nowhere did they come even remotely close to that standard. This person criticized the judge for their rulings, which they're more than free to do. They're more than free to criticize the rulings, as I'm free too. And if you want to come arrest me, Michigan, come at me. You come at me, bro, you know, because I can't believe this in my deepest heart of hearts that this was, what slow words do I have to use to explain the First Amendment to these people and basic constitutional freedoms? That you have the right to criticize the judge. Yeah, you have a right to criticize the judge, just like anyone else. Amazing concepts at work. You don't have the right to threaten anyone. You don't have the right to harass anyone. You do have the right to criticize. You do have the right to express an opinion. So, like, unbelievable. I cannot believe that it got so far as a jury trial. I cannot believe it got so far as a jury verdict. I feel like it should have been thrown out long ago, but you know, thank goodness that it was found not guilty. And, you know, you go on, guy, and keep criticizing the system and keep digging up that corruption, because it feels like a lot of corruption you have to go. And I hope that you'll be testifying soon at a future bar complaint, because this needs to be adjudicated. And if I were a Michigan attorney, I'd be sorely tempted to file a bar complaint myself. But I'm not a Michigan attorney. Now, strictly speaking, that doesn't preclude me from filing. I just don't have any particular standing. They're not going to listen to me. I'm a random guy. But if I were a Michigan attorney, I'd be sorely tempted to file a bar complaint myself, because this is ridiculous. We have potentially much happier story, depending on your point of view. So we can look forward to something about freeing the nipple, guys. You're gonna be topless in the West. We can have some good news about that. Our next story is Free the Nipple Fort Collins versus the city of Fort Collins. This is a case dealing with whether or not women have the right to go topless in Fort Collins, Colorado, and by extension in the 10th Circuit Court of Appeals, which recently decided this case and which judgment just recently became final. The 10th Circuit Court of Appeals includes Utah, which of course is pretty interesting. So we're going to read this decision and we're going to see what the Court of Appeals had to say in terms of the constitutional right of women to go topless in Colorado and other states of the 10th Circuit. So let's read this and see what they had to say. The city of Fort Collins, Colorado enacted a public nudity ordinance that imposed no restrictions on male toplessness, but prohibits women from baring their breasts below the areola. In response, Free the Nipple, an unincorporated association, and two individuals sued the city in federal district court. They allege other things, that the ordinance violates the Equal Protection Clause, and they asked for a preliminary injunction to halt enforcement of the ordinance. The district court agreed, enjoined the city, pending resolution of the case on the merits, from implementing the ordinance to the extent it prohibits women, but not men, from knowingly exposing their breasts in the public. The city then brought this interlocutory appeal to challenge the injunction. This appeal presents a narrow question. Did the district court reversibly err in issuing the preliminary injunction? We answer no. Exercising interlocutory judgment, we affirm the district court, and this judgment has since become final. So we're going to read what they said. No state shall deny to any person within its jurisdiction the equal protection of the law. The Equal Protection Clause, as the United States has interpreted it, directs that all persons similarly situated should be treated alike. At a minimum, it requires that any statutory classification be rationally related to a legitimate government purpose. But more stringent judicial scrutiny attaches to classifications based on certain suspect characteristics. These characteristics often seldom provide a sensible ground for differential treatment. Gender, for instance, frequently bears no relation to an ability to perform or contribute to society, and statutes that differentiate between men and women very likely reflect outmoded notions about relative capabilities. As a result, gender-based classifications call for a heightened standard of review, which is dubbed intermediate scrutiny because it lies between the extremes of rational basis and strict scrutiny. To survive intermediate scrutiny, a gender-based classification needs an exceedingly persuasive justification. The classification must serve an important governmental objective through means substantially related to achieving the objective. The city acknowledges that the female-only topless ban is gender-based classification and that to pass muster under equal protection, gender-based classifications must satisfy intermediate scrutiny. But instead of drawing the logical conclusion that female-only topless bans warrant intermediate scrutiny, the city interrupts the syllogism. It asserts that the fundamental requirement of any cognizable gender discrimination case is invidious discrimination, not simple classification on the basis of gender. Some of the court's early protection cases, such as 1979's Parham versus Hughes, did treat invidiousness as a threshold inquiry. Yet Parham, if never overruled, is outlined in light of court's more modern equal protection jurisprudence. Since then, the court has consistently recognized that statutes supposedly based on reasonable considerations may in fact relate to archaic and overbroad generalizations about gender or outdated misconceptions regarding the role of females in the home rather than the marketplace and world of ideas. Today, hardened scrutiny attends all gender-based classifications. Invidiousness still matters, but only in challenges to facially gender-neutral statutes that disproportionately and adversely impact one gender. Here, however, the city has enacted, and plans to challenge, a public nudity ordinance that prescribes one rule for women, requiring them to cover their breasts below the areola, and a different rule for men, allowing them to go topless as they please. The ordinance creates a gender classification on its face, taking invidiousness out of the equation. The success of the equal protection claim depends only on whether the ordinance survives intermediate scrutiny. The district court categorized as little more than speculation the city's claim that banning only flameless toplessness further important governmental objectives. Instead, the court found the ordinance discriminates against women based on generalized notion that, regardless of a woman's intent, the exposure of breasts in public, or even private home if viewable to the public, is necessarily a sexualized act. Thus, it perpetuates a stereotype ingrained in our society that female breasts are primary objects of sexual desire, whereas male breasts are not. As a result, the court concluded that plaintiffs demonstrated a strong likelihood that they will succeed at permanent injunction trial in establishing that the ordinance violates the Equal Protection Clause. The city challenges this conclusion on appeal. It argues that, in light of differences between male and female breasts, prohibiting female toplessness is substantially related to an important governmental objective, and the sizable majority of other courts have so found. We address the city's argument in two parts. Further, we discuss the focus of the city's defense, the physical differences between male and female breasts, and explain how such differences affect the constitutional analysis. Secondly, we determine whether the city's female-only toplessness ban survives constitutional scrutiny. In defending the constitutionality of the public nudity ordinance, the city emphasizes the physical, social, and sexual characteristics particular to the female breast. Citing a Wikipedia article, the city argues that the woman's breasts have social and sexual characteristics, although their primary function is breastfeeding. The article, as quoted by the city, describes female breasts, and especially nipples, as among the various human erogenous zones, and claims it's common to press or massage them with hands during a sexual activity. The city claims that it figures prominently in women's perception of her body image and sexual attractiveness, and have held sexual status in Western culture, arguably more fetishized than genitalia. But the sexualization of women's breasts is not solely a product of social norms, but also biology. Women suggest that the breasts have greater tactile sensitivity than men's. Though we're wary of Wikipedia's user-generated content, we agree that the district court that, of course, inherent physical districts exist between women and men's breasts, most obviously in the unique potential to nourish children. But this does not resolve the constitutional query. Physical differences between women and men the court has recognized are enduring. In some cases, the court has found such differences justify differential treatment, but not always. Any law premised on generalizations about the way women are or the way men are will fail constitutional scrutiny because it serves no important governmental objective. Generalizations, the court has explained, have constrained impact, descriptive, though they may not be aware of many people still ordered in their lives. So as we inquire into gender-based classification objects, we must beware of stereotypes and their potential to perpetuate inequality. Even stereotypes frozen in legislation that have statistical support, we must reject measures that classify unnecessary and overbroad by gender when more accurate lines can be drawn. The city argues that the inherent sexual nature of the female breast as opposed to the male breast raise myriad concerns with permitting adult females to go topless in public without restriction. The city refers this to a preliminary injunction hearing in which three officials, the deputy city manager, the assistant chief of police, and the city's aquatics supervisor, discussed some of these concerns. The officials testified that female toplessness could disrupt the public order, lead to distracted driving, and endanger children. Citing these concerns, the city prohibits only female toplessness serves to protect children from public nudity, to maintain order, and to promote traffic safety. And we discuss each of these rationalizations in turns. The capacity to breastfeed is the first attribute the city claims sets the female breast apart. Yet the city's public nudity ordinance expressly exempts breastfeeding women from the toplessness ban, so even children who weren't exposed to their mother's breast as breastfeeding infants may still see a naked female breast if they pass by a woman breastfeeding in public, her right under the state law. The need to protect children arises instead from the city's fear of topless women parading in front of elementary schools or swimming topless in public pools, scenarios it described to the court at a preliminary injunction hearing. But the laws in neighboring cities of Boulder and Denver and many other jurisdictions allow for female toplessness, and the city presented no evidence of any harmful fallout. In fact, the district court found that the city provides no evidence that a law permitting public exposure of female breasts would have any significant negative impact on the public. In absolutely contrary proof, we, like the district court, found out that without female toplessness ban on the books, topless women would regularly walk through downtown Fort Collins, parade past elementary schools, or swim in public pools. We're left, as the district court was, to suspect the city's professed interest in protecting children derives not from any morphological differences between men and women's breasts, but from various stereotypes depicting women's breasts but not men's breasts as sex objects. But laws grounded in stereotypes about the way women serve are not important to governmental interests. To the contrary, legislatively reinforced stereotypes tend to create a self-fulfilling cycle of discrimination. Thus, the sex object stereotype, according to Dr. Roberts, serves a function of keeping women in their place. And the district court found perpetuating sex object stereotype leads to negative cognitive, behavioral, and emotional outcomes both for women and men. The court noted, for instance, that Dr. Roberts has testified about research linking sexual objectification of women to the view that at younger and younger ages, women are viewed as targets for sexual assault. Excuse me one second. So what's left? A female-only toplessness ban strikes us as unnecessary and overbroad means to maintain public order and promote traffic safety when more accurate and impartial lines can be drawn. For instance, the city could abate sidewalk confrontations by increasing the penalty for engaging in offensive conduct, and to reduce distracted driving, the city could target billboards designed to draw eyes from the road. But the city cannot impede women and not men's ability to go topless unless established a tight means ends that survives intermediate scrutiny. We recognize that ours is a minority viewpoint. Most other courts, including a recently split Seventh Circuit panel, have rejected equal protection challenges to female-only topless bans. None of these decisions bind us, though, nor does the sheer volume outweigh our analysis. As we interpret the arc of the court's equal protection jurisprudence, we've reached our constitutionally sound result. At least since the case called Virginia, the arc bends towards requiring more, not less, judicial scrutiny when asserted physical differences are raised to justify gender-based discrimination, while casting doubt on public morality as a constitutional reason for gender-based qualifications. For these reasons, we believe the district court correctly analyzed the plaintiff's equal protection claim. The court did not abuse its discretion in concluding that because the plaintiffs made a strong showing of their likelihood of success on the merits, the first preliminary injunction favor weighed in their favor. So that is the end of the case as it relates to Free the Nipple Fort Collins versus the City of Fort Collins. And as I indicated in the 10th Circuit Court of Appeals, there's now a general requirement that women can go topless if men can go topless. But as the 10th Circuit noted, there is a split of authority on this. The 7th Circuit has gone the other way, and I believe the 8th Circuit has gone the other way. Although the city of New York agrees with the 10th Circuit and some other cities agree with the 10th Circuit as well. So there is a split of authority on this issue. Now, it's unclear that there's any issue for the U.S. Supreme Court here to resolve because all these issues involve local bans or local regulations. So they're all interpreting local regulations, not a federal law or a constitutional issue. I suppose the U.S. Supreme Court could get involved to further clarify its equal protection grounds. But even though there is a split of circuits on this issue, they're all interpreting local ordinances, so it's not particularly immediately clear that the United States Supreme Court would grant cert on this issue, and if they did, what kind of judgments they would be giving, except maybe to clarify the equal protection analysis under the intermediate scrutiny analysis as it relates to this or other issues. But we'll see if there's any appetite. This case did not get appealed to the U.S. Supreme Court, which is one of the reasons it's now in effect. But with a circuit split, maybe one of them will someday petition for a writ of certiorari, and we'll see if the court wants to get involved, but that's not going to happen today. So that's all that there is about this case. All right. How are we all doing, everyone? Still going okay? We got 2 more stories, I think. For our next story, we have the state of California et al. Versus the United States federal government as it relates to the regulation of standards for tailpipe emissions for cars. So the state of California and other states have regulations as it relates to this, and the U.S. federal government has regulations as it relates to this. So one of the questions is whether or not the state of California can regulate in a way that's inconsistent with federal law. So we're going to read the state of California's complaint and see what they say in terms of the Trump administration or other administrations attempting to force all the states to conform to U.S. federal guidelines as it relates to more stringent emissions standards as it relates to cars. So let's get started with this decision. Plaintiff, the states of California, Colorado, Connecticut, Delaware, Hawaii, Illinois, Maine, Maryland, Minnesota, Nevada, New Jersey, New Mexico, New York, North Carolina, Oregon, Rhode Island, Vermont, Washington, and Wisconsin, the Commonwealths of Massachusetts, Pennsylvania, and Virginia, and the people of the state of Michigan, the District of Columbia, and the city of Los Angeles and New York allege as follows. The plaintiffs bring this action for declaratory and injunctive release against final regulations of the National Highway Traffic Safety Administration to be codified in the Code of Federal Regulations and appendices to the parts. The signed register publication versions is attached. The state plaintiffs respectfully request that the regulation be declared unlawful and set aside because it exceeds the federal government's authority, contravenes congressional intent, and is arbitrary and capricious, and because the NHTSA has failed to conduct the analysis required under the Environmental Protection Policy Analysis. The preemption regulation declared that Federal Energy Policy and Conservation Act of 1975 preempts state law that regulates greenhouse gases from new passenger cars and light trucks. The preemption regulation targets the name of greenhouse gas emissions and zero emissions vehicle standards promulgated by the state of California and adopted by 12 other states. California has had emission standards for light-duty vehicles for 60 years, and California standards at issue are long-standing and fundamental parts of many states' plaintiffs' efforts to protect the public health and welfare in their states, to meet state goals for reduction of harmful air pollution, including greenhouse gas, and to attain or maintain federal air quality standards. Indeed, the California standards are one of the most effective state policies to reduce greenhouse gases and other pollutant emissions from the transportation sector. California standards are projected to result in more than 2 million additional zero-emission vehicles on the road by 2025, and in the absence of existing federal standards, to reduce greenhouse gases by more than 66 million metric tons by 2030, greater than the amount emitted by all the power plants in California. The federal government has repeatedly approved several plaintiffs' use of California standards as necessary for a wide variety of purposes. It's granted waivers under the preemption under Section 209 of the Clean Air Act, both for greenhouse gases standards and for zero-emission vehicles. The federal government has also approved these standards as necessary components of several plaintiffs' plans to attain national ambient air quality standards under the Clean Air Act, and has approved state reliance on zero-emission vehicle standards in determining the pollution impact on transportation planning decisions. Moreover, for the last decade, the federal government has harmonized its own greenhouse emission standards as fuel economy standards with California standards. And California has been widely regulating vehicle emissions since 1959. The preemption regulation declares that California's decades-old zero-emission vehicle standards are both related to fuel economy standards and in conflict with them. Preemption regulation, page 50. But the regulation itself demonstrates the opposite. Congress has not authorized NHTSA to set fuel economy standards for vehicles, including zero-emission vehicles that run exclusively on alternative fuels like electricity, and has prohibited the federal government from taking the availability of zero-emission vehicles into account when setting federal fuel standards, meaning that zero-emission vehicles do not affect fuel economy standards. See. So now they're discussing a lot of history in terms of what various parties have done historically, which is relevant for setting the tone, but let's get to the heart of the issue, as it were. NHTSA proposed the preemption regulation as part of a joint EPA-NHTSA rulemaking package published in the Federal Register. As part of the same package, NHTSA proposed to weaken the existing fuel economy standards for model year 2021 so that it would be no more stringent than the model 2020 level. NHTSA also proposed to set fuel economy standards at the same level for 2022 through 2026. EPA proposed to weaken existing federal standards for model years 2021 through 2026 so they'd likewise be frozen at model year 2020 levels and to revoke the California's waiver under the standards that had previously applied. The final preemption regulation was signed by Defendant Owens, the Transportation Secretary, on September the 19th, 2019. The final preemption was not accompanied by any action changing or setting NHTSA economy standards. However, the preemption regulation does appear in the same pre-publication notice. Let's see. The preemption regulation declares that California standards conflict with national standards, even though automakers have been able to meet California standards by complying with federal greenhouse standards that were issued in the joint rulemaking. In the preamble to the proposed regulations, NHTSA claims to comply with requirements of Executive Order 13132, which imposes requirements on agencies that promulgate regulations. That order has particular requirements for preemption regulations. Among other things, it requires agencies must consult with states early in the process. And NHTSA did not consult with them early in the process. The preemption regulation is contrary to law because it interprets the statute as expressly and implicitly preempting state laws regulating or prohibiting or having direct or substantial effect of regulating or prohibiting tailpipe greenhouse emissions, regardless of whether the EPA has waived Clear Act preemption of those laws under Section 209 of the Clean Air Act. The preemption regulation is contrary to law because it conflicts with congressional intent, as recognized by the Supreme Court, to establish two distinct statutory schemes for separate regulation of vehicles and fuel economy. The preemption regulation wrongly interprets Congress's adoption of the statute as implicitly revoking California's authority to set vehicle emission standards, at least with respect to the greenhouse gases. That interpretation is contrary to Congress's direction in the statute that NHTSA consider and give effect to California emission standards. It's also contrary to further congressional action reaffirming and expanding California's authority to set vehicle emission standards that Congress recognized could affect fuel economy, including 1977 amendments to the Clean Air Act and 1994 recodification of the statute. The preemption regulation is also contrary to law because it disregards Congress's express recognition of California's greenhouse gas standards in the statute and Congress's express recognition of California's zero-emission vehicle standards in the 1990 emissions to the Clean Air Act. The preemption regulation violates NHTSA's general conformity obligations under Section 176 of the Clean Air Act to refrain from taking actions that frustrate states' abilities to attain or maintain national ambient air quality standards. By purporting to declare preempted the California standards that previously recognized as necessary for several state plans to attain or maintain those standards, the NHTSA action will cause increased criteria pollutant levels in ambient air and interfere with state plans' efforts to attain or maintain those standards. In connection with other foreseeable actions, the preemption regulation will contribute to new violations in non-attainment or maintenance areas in a manner that will increase the frequency or severity of new violations. The preemption regulation is unlawful and arbitrary and capricious because it violates and fails to consider the statute's objectives of conserving energy and promoting development of vehicles powered by less conventional energy sources such as electricity. Preemption regulation is arbitrary and capricious because NHTSA fails to adequately explain how preemption of laws is necessary to maintain federal air quality standards, does not interfere with the state's ability to maintain those standards. The federal regulation is arbitrary and capricious because it fails to address or consider state reliance, approval by EPA on zero-emission vehicle standards for the purposes of transportation conformity under Section 176. The preemption regulation is unwarranted by the facts because it purports to declare the California standards conflict with congressional objectives for the statute, but the NHTSA has not identified and cannot identify any actual evidence of a conflict, despite the fact that California has had enforceable zero-emission vehicle standards for more than 20 years and greenhouse gas standards for 9 years. Yeah. So that is the state of California versus the U.S. federal government. So the U.S. federal government, through its proposed rulemaking, has proposed a rule that would, under the U.S. terms, codify and preempt, which is to say that no state can regulate in this area. So all states would be bound by the federal regulation, and no state could regulate more strictly than the federal government standards. So the state of California, which has more stringent regulations, would be unable to have those regulations in place. Now, preemption is something the federal government can generally do to preempt the field, but when it does so, it must do so clearly and unambiguously. It must make it clear that Congress is preempting the field. So the general complaint here is that the Congress has not done so, and in fact, in its legislation has directly indicated that there should not be preemption, and the state of California has a reliance interest on previous waivers granted, and the federal government does not have an interest in not granting those waivers under these regulations. It's particularly where the state of California is trying to meet the federal regulations. So, on balance, from the state of California's complaint, I would say the state of California has a legitimate complaint. Now, of course, we have not seen the federal government's response to this yet. We've not seen their argument yet. So we don't know the strength of the federal government argument. But on the face of the complaint brought by the state of California, I would rate their complaint as fairly plausible and states forth a good and well-pled cause of action. Whether or not they're right or not, we'll have to wait for further development. But it seems like a reasonable complaint on its merits. The state of California has some legitimate grievances here, but perhaps the federal government is right and these are preempted. We'd have to get much deeper into the Administrative Procedure Act, and the federal government's argument is going to do that for us in terms of the preemption issues. So I look forward to reading the federal government's response that's going to get into those preemption issues, really get into the meat of the statutes in terms of whether their authority to grant this waiver or not is preempted or not, and we'll see what happens forward. But so far, an interesting complaint. We'll see what happens next. Ow. Okay. This is our last case for today. For those of you who are planning ahead, for our next case, we have the opinion of the Third Circuit Court of Appeals in the case of Surinder Maline versus the United States Secretary for the United States Department of State and the Attorney General of New Jersey. So this case deals with child support. So basically what happened is that a father was ordered to pay child support, and then at some time later he acquired custody of the child, but the state refused to lessen his child support payments even though he had custody, and that would normally be factored in. So the Third Circuit Court of Appeals is being asked to render a judgment as to whether that was proper. So let's So the Third Circuit Court of Appeals is being asked to render a judgment as to whether that's proper. So let's see what they had to say in this case. This case arises out of a family law dispute that began in 2011 and remains pending in Hudson County, New Jersey. Over the past 8 years, the family court has required appellant Surinder Maline to pay some $300,000 in child and spousal support to his putative ex-wife, Alina Minova. The crux of Maline's complaint is that New Jersey officials violated his federal rights when they failed to reduce his support obligations after he was awarded custody of their two children and his wife obtained a job that pays more than his own. The district court dismissed the complaint, holding that it lacked jurisdiction under Rooker-Feldman doctrine. And to the extent it had jurisdiction, the district court declined to exercise it under Younger v. Harris. In our view, Mellon is entitled to federal court relief and review on some claims, so we affirm in part, reverse in part, and remand for further proceedings. So just by way of background here, when they're talking about Rooker-Feldman doctrine, they're talking about Younger v. Harris, they're talking about cases called abstention doctrine. So there has been in federal law issues where the federal court, even where they have had jurisdiction in the past, have refused to hear certain cases under what's called abstention doctrine. And those relate to cases involving state level courts and state level things. So even where a federal government has had jurisdiction in the past, they've often declined to hear the case. Now, this is not much of a thing as it used to be, but these cases are still in the books. So that is basically the issue. Should the district court have refused to hear the case under the abstention doctrine? So the issue isn't, did the district court have the power to hear the case? The issue is, should the district court, notwithstanding have the power to hear the case, not hear the case anyway because of this abstention doctrine kind of stuff. So this is pretty sort of geeky stuff as far as it goes on sort of procedural stuff, and should be really interesting for us to learn something about abstention doctrine law as it relates to the federal courts, both now and in the past. So let's read and see what the federal courts has to say as it relates to abstention doctrine and whether district courts should hear certain kinds of cases, even though they have the power to or not. We first addressed the district court's holding that lacked jurisdiction under the Rooker-Feldman. That doctrine conflicts with the familiar maxim that federal courts have virtually unflagged duty to exercise jurisdiction conferred by Congress. At the same time, federal district courts are not amenable to appeals from disappointed state court litigants. A litigant seeking to appeal a state court judgment must seek review in the United States Supreme Court. As this court has explained, Roker and Feldman exhibit the limited circumstances in which the court's appellate jurisdiction over state judgments precludes a United States District Court from exercising subject matter jurisdiction in an action it would otherwise be empowered to adjudicate under a congressional grant of authority. Although those limited circumstances arose only twice in the United States Supreme Court, in Rooker and Feldman themselves, lower courts have applied the doctrine liberally for some time. That changed in 2005 when the court decided Exxon. There, the court reversed our expansive interpretation of Rooker-Feldman and confined the doctrine to those cases of a kind from which it acquired its name, cases brought by a state court loser complaining of injuries caused by state court judgments rendered before district court proceedings commenced and inviting district court review and rejection of the judgment. Given those elements, the problem with the district court's application of Rooker-Feldman is readily apparent. Moline does not complain of injuries caused by a state court judgment. In fact, as the district court implied in its order denying reconsideration, there's no judgment at all because Moline is complaining of findings and determination of a family court. But does Rooker-Feldman apply to family courts' interlocutory orders? The answer is less than clear. Before Exxon, we thought Rooker-Feldman barred review of interlocutory state orders that resolved, at least for the moment, the dispute between the parties which forms the basis of federal complaint. Since Exxon, we've now addressed whether port authority remains good law, and the decision of our panels and district courts have been inconsistent. Exxon itself offers conflicting guidance. On the one hand, judgment might include non-final orders like preliminary injunctions. That reading would follow the federal rules of civil procedure. On the other hand, Exxon describes Rooker and Feldman as cases which the losing party in state court filed suit in federal court after the state proceedings ended. That language suggests Rooker-Feldman applies only to final state court judgments, and the court holding a Rooker-Feldman is confined to the cases of kind from which the doctrine acquired its name invites disagreement about the scope of Rooker and Feldman. Fortunately, 6 of our sister circuits have reconciled Exxon's different readings by holding that interlocutory orders are judgments only when they're effectively final. The foundational case in this practical finality approach is the First Circuit. 5 other circuits have cited this with approval. Federation outlines 3 circumstances in which there's a Rooker-Feldman judgment. The first is where the high state court in which review is available has affirmed the judgment below and nothing is left to be resolved. Then the judgment is final judgment or decree rendered by the highest court of a state in which a jurisdiction could be had. The Supreme Court has exclusive jurisdiction in those cases, and state proceedings have ended under Exxon. Second situation in which state action has reached a point where neither party seeks further action. An example is where a lower court issues a judgment and the losing party allows its time for appeal to expire, or the lower state court does not issue a judgment but merely an interlocutory order, and the parties then voluntarily terminate the litigation. In this situation, unlike the first, there's usually not an appealable final judgment or decree rendered. Lastly, there is a judgment where a state proceeding has finally resolved all the federal questions in litigation. Even though state law or purely factual questions remain to be litigated. The First Circuit based this scenario on the Supreme Court's second footnote in Exxon. Our holding thus ensures we do not review state court proceedings that have ended, even where the Supreme Court lacks jurisdiction. That satisfies Exxon and limits the interlocutories that count as judgment to those over which the court has jurisdiction. That respects Ruker and Feldman's jurisdictional basis. Applying these principles, we hold that none of the interlocutory orders in the Milan state case are judgments. For one, they're not final judgments or decrees rendered by the New Jersey Supreme Court, nor have they finally resolved all the federal questions and litigations, or has satisfied practical finality under different case law. Milan has several motions pending since 2016. Discovery is incomplete. No trial is scheduled, and the family court has made clear so far that Milan's support obligations will not be changed until a final divorce decree is entered. His state court proceedings are far from ended. Having established that the district court had jurisdiction over the federal claims, we consider whether the court erred by abstaining from exercising that jurisdiction. To promote comity between national and state governments, Younger requires federal courts to abstain from deciding cases that would interfere with certain ongoing proceedings. In deciding to abstain, the district court considered three factors announced by the Supreme Court in Middlesex County Ethics Committee versus Garden State Bar Association. That is, whether there are ongoing state proceedings that are judicial in nature, the state proceedings implicate important state interests, and the state proceedings afford an adequate opportunity to raise federal claims. But much has transpired since Middlesex was decided almost 40 years ago. In Sprint, the Supreme Court underscored that Younger's abstention conflicts with federal courts' general unflagged obligations to exercise jurisdiction. And just as Exxon and its progeny limited Rooker-Feldman, Spirits narrowed Younger's domain. The court explains, and we have stressed several times since, that three Middlesex conditions are no longer the test. Instead, Younger applies only to three exceptional categories of proceedings: ongoing state criminal prosecutions, certain civil enforcement proceedings, and pending civil proceedings involving certain orders uniquely in furtherance of the state court's ability to perform judicial functions. Only after a court finds its proceedings fits one of those descriptions should it consider Middlesex's additional factors. Otherwise, divorced from their quasi-criminal context, the three Middlesex conditions would extend Younger to virtually all parallel state and federal proceedings. Excuse me again. Spirit's first two categories do not apply here. None of Milan's count involve a criminal prosecution, nor do any challenge a civil enforcement proceeding akin to a criminal prosecution. Milan's wife, not the state, began the family court case. The case is not sought to sanction Milan for wrongful, enforce a parallel criminal statute, or impose quasi-criminal investigation. Rather, it sought only to distribute its assets equally in the interest of the children and the putative ex-wife. So we ask whether the counts involve certain orders unique in furtherance of the state court's ability to perform the function. Count 2 involves an administration collection of non-final money judgments. It does not challenge how a court protects its status quo pending appeal, as in Pennzoil, when bond money was collateral in lieu of immediate execution, nor does it challenge the process, such as civil contempt, that is separate from the merits and that ends when the defendant complies. In fact, Count 2 does not challenge any judicial order at all. It challenges executive actions that have a layer of family court review. Milan's proceedings are nothing like those of Judas or Pennzoil. The family court vacated its garnishment order last year and has not issued another. No fact finder has returned a verdict. No judgment waits to be entered. So Milan faces only threatened garnishment. Like the plaintiffs in Woodley and Sterrell, he can seek wholly prospective relief. That relief has pled in count 6, that is, the district court declare under Declaratory Judgment Act the garnishment of custodial parents' wages is prohibited under the Child Support Enforcement Amendments of 1984. Preliminary and permanently enjoin the state's dependent from garnishing the salary so long as he's custodial parent, and the alternative, grant declaratory and injunctive relief to Milan that state defendants may not garnish payments which are not earnings nor garnish payments above what is permitted by the Consumer Protection Act. On those terms, Milan is not trying to annul the results of a past garnishment, so he may present count 6 in district court. The district court has federal question jurisdiction and should have fulfilled its virtually unflagging obligation to exercise jurisdiction. We will reverse its application of Roker-Feldman and Younger. The district court has federal question jurisdiction and should have fulfilled its virtually unflagging role and obligation to exercise that jurisdiction. We will reverse its application of Roker-Feldman and Younger as to counts 2, 5, and 6 and remand for proceeding on the merits. We affirm with dismissal of counts 1, 3, and 5. So that is the end of this case from the Court of Appeals for the Third Circuit dealing with Surrender Milan versus the state of New Jersey as it relates to his child payments and saying the district court could have jurisdiction. So a pretty interesting case for lawyers as it relates to procedural issues and discussion of these abstention doctrines and relating to the fact that there used to be a lot more on this, but a 2005 case called Exxon changed the balance substantially, as the Supreme Court has the right to do. As a result, the district court can hear this because the preemption doctrines are much narrower than they used to be. So you can go back to district court and try to get some relief there. So all in all, pretty interesting. Helps to inform me a lot as to what's going on in this area of preemption law. Not something I've had to encounter a lot because my field of patent law doesn't have any state law components, so I don't have to worry about preemption law. But it is really interesting to read something and learn a little bit something about federal rules of procedure as it relates to preemption and other kinds of cases. So if you have a state cause of action, you may be able to get to federal court too. So pretty interesting stuff, all things considered. All right, friends, that's the end of the stream. We have covered all the cases I have. We've covered our entire week's worth of stuff. I hope you found it interesting and informative. And as always, incidentally, just FYI, I kind of quasi-announced this, but I just got an email from Twitch saying that I can be a partner. Now, as I understand the rules, if I choose to be a partner, that means I can't live stream on YouTube if I choose to live stream on Twitch. So I'm disinclined to accept Twitch's offer because I think I'm getting more traction on YouTube, and I'm much more interested in building the YouTube than I'm interested in building Twitch. But if anyone has a vote on that and would like to convince me otherwise, feel free to message me on Discord, and we can discuss the relative merits of me accepting or declining Twitch's offer with terms of live streaming there. So if anyone has some thoughts, let me know. So that's all for today. I hope this was helpful. Look forward to talking with you guys throughout the week on Discord. Until later, my friends. Cheers and goodbye.